The defendant at trial was 15. The charge was arson. In my transcript, the certified, sealed, filed official transcript, there is a passage on page 41 where the defendant describes the night he set the fire. He never said those words. I was there. I was 8 feet from the witness stand. My fingers were on the keys. I took down everything he said and everything he didn't say, because that is what I have done for 11 years, and I have never missed a line. Page 41 contains 19 lines of testimony that did not occur in courtroom 6 on October 14th. But they are true. I need to explain how I know that, and I need to explain what I did about it, and I need to explain why I am now sitting in my car in the parking structure of the Hennepin County Government Center in Minneapolis at 6:14 in the evening, engine off, unable to make myself drive home. My name is Dana Keeling. I'm a certified shorthand reporter for the 4th Judicial District, State of Minnesota. I hold the RPR and RMR certifications through the National Court Reporters Association. I have been the primary reporter assigned to Judge Carolyn Oda's courtroom, Courtroom 6, 8th floor, for 7 years, and I sat in other courtrooms for 4 years before that. I average 240 words per minute with an accuracy rate that has never dropped below 98.4% on any proficiency review. I am telling you this not to boast, but because you need to understand that I do not make the kind of mistake I am about to describe, and that the institutional infrastructure around me does not allow for it, and that it happened anyway. Court reporting is not what people think. They imagine a woman sitting silently in the corner, typing. They are correct about the sitting and the silence and the typing, but they are wrong about everything underneath it. What I do is translate the human voice into a phonetic shorthand in real time, at the speed of natural speech, through a 22-key machine that produces output no one else in the room can read. That output runs through CAT software, computer-aided transcription, on my laptop, where my personal dictionary converts the steno into English. After the proceeding ends, I edit the raw translation, correct mistranslates, verify spellings, insert punctuation, format according to state and federal guidelines, and produce a certified transcript that becomes the permanent legal record of what was said. Everything I write is official. When I sign the certification page at the back of a transcript, I am attesting under penalty of law that the document is a true, correct, and complete record of the proceedings. My signature is the last thing between spoken words and legal permanence. Once I certify, the transcript becomes what happened, regardless of anyone's memory. This is not a responsibility I have ever taken lightly. I set up in courtroom 6 each morning by 7:45. The routine is fixed. I place my Luminex 2 on the small desk to the left of the bench, angled so I have an unobstructed sight line to the witness stand, the counsel tables, and the gallery. I connect my laptop via USB, open my CAT software, I use Eclipse, and load the dictionary file specific to whatever case is on the docket. I test my keys. I check that the backup audio recorder beneath my desk is running. The 4th District mandates a redundant audio capture for all felony proceedings. I confirm the date, case number, judge, counsel, and parties, and I type the header for the day's transcript. By 8:15 I am ready. By 8:30 Judge Oda takes the bench. By 8:31 I am writing. The case that matters, the one I can't drive away from, is State of Minnesota versus Elias Ruiz. Elias was 15 at the time of the fire. He was charged with first-degree arson for setting a blaze that destroyed a 2-unit residential structure on 26th Street in the Phillips neighborhood on the night of August 9th. No one died, but a 63-year-old woman named Tan Pham suffered third-degree burns on her arms and hands. Elias was tried as an adult. His public defender was a woman named Gretchen Hauer, who I had seen in courtroom 6 many times and who was competent in the specific way that overworked attorneys in a major metro court system are competent: good instincts, poor resources, no time. The trial lasted 4 days. The prosecution presented physical evidence, witness testimony from neighbors, and Elias's prior juvenile record. Gretchen's defense was that Elias had been present at the scene but had not set the fire, that the building's landlord had a documented history of electrical code violations, and that the fire investigator's origin and cause report was inconclusive on the question of accelerant. It was a reasonable defense with a structural weakness. Elias had told 3 different stories to 3 different people in the 72 hours after the fire, and the prosecution had all 3 on the record. I wrote every word of the trial. I wrote the opening statements and the cross-examinations and the sidebar conferences where Judge Oda leaned over and spoke in the low, measured voice she uses when she is unhappy with both attorneys simultaneously. I wrote the forensic testimony about burn patterns and the neighbor who cried on the stand describing how she heard Tan Pham screaming. I wrote Gretchen's closing argument, which was precise and underfunded and not enough. On the 3rd day of trial, Elias took the stand in his own defense. This is where I need to be very precise. Elias testified for 47 minutes on direct examination and 31 minutes on cross. I captured every word. My real-time feed was running to the judge's monitor and to both counsel tables, as it does in all felony trials in our courtroom. The feed is unedited, raw steno to English translation, and attorneys use it to track testimony in real time, flag passages for later reference, and formulate follow-up questions. Judge Oda glances at it periodically. It is not the final transcript, but it is a live window into my output. During Elias's testimony, nothing unusual happened. He was nervous. His voice cracked twice. He avoided eye contact with the prosecutor and stared at his hands when asked about the night of the fire. He described being at a friend's house, leaving around 10:30, walking south on Bloomington Avenue, seeing smoke from 2 blocks away, and approaching the building out of curiosity. He denied having any accelerant. He denied entering the building. He said he called 911 from a phone he borrowed from a woman at the bus stop. None of this was verifiable through his cell phone records because he didn't own a cell phone, a fact the prosecution used to imply he was being evasive about his movements. The jury was attentive. Gretchen asked careful, open-ended questions. The prosecutor's cross was aggressive but procedurally clean. Judge Oda sustained 2 objections from the defense and 1 from the state. I wrote all of it. The trial concluded on a Friday. The jury deliberated for 6 hours and returned a guilty verdict on Monday morning. Judge Oda scheduled sentencing for November 12. I began preparing the certified transcript the following week. This is where the work changes character. During a proceeding, I am writing raw steno in real time. Afterward, I am editing. I go through the entire translated output line by line, correcting untranslated steno strokes, fixing homophone errors, inserting proper punctuation, formatting speaker identifications, and ensuring that the final product reads as a faithful record of what was spoken. This is meticulous, slow work. A 4-day trial can take me 2 full weeks to produce a final transcript, and I treat every page as if someone's freedom depends on it, because it does. I was editing Elias's direct examination testimony on a Wednesday afternoon, 8 days after the verdict. I was on page 39 of the transcript. My office is a shared space on the 9th floor, 3 court reporters in a room with particle board dividers. Mariana Solis was at the desk behind me working on a civil deposition. Kevin Brandt was out sick. The overhead fluorescents hummed at the frequency they always hum at, and my coffee was cold, and the building's HVAC was producing the specific dry heat that makes my eyes itch by 2 in the afternoon. I was editing a passage where Gretchen asked Elias what he saw when he arrived at the building. The raw steno to English on my screen read *Q. And when you got to the building, what did you see? *A. There was smoke coming from the first floor. The windows they were like orange. From the fire inside, *. This matched what I remembered from the courtroom. I corrected a minor formatting issue, the dash placement, and moved to the next exchange. The next exchange on my screen read *Q. Did you go inside the building? A. No. *Q. Did you see anyone else near the building? A. There was a man on the sidewalk across the street. He was watching. I stopped. I stared at the passage. Gretchen had not asked that question. Elias had not given that answer. The question and answer about a man watching from across the street did not happen in courtroom 6. I was certain of this, not in the hedged way people are certain about memories, but with the professional certainty of someone who captured every syllable in real time while a live feed ran to 3 monitors. My first assumption was a software error. Eclipse is sophisticated, but cat dictionaries are user-built, and misstrokes can produce phantom text. I had seen it happen, not to me, but to other reporters. A chord meant for one word gets mapped to a sentence fragment in the dictionary, and something incoherent appears in the translation. But this passage was not incoherent. It was clean, grammatically correct, properly formatted, and responsive to the prior answer in a way that no dictionary error could produce. I checked my steno notes. The raw shorthand on my machine's internal memory showed the corresponding strokes for every word in that passage. My hands had typed it. Or my machine had recorded strokes that corresponded to it. There is a difference, and at that moment, sitting in my office with Mariana clicking her mouse behind the divider, I could not determine which was true. I pulled up the backup audio recording from the courtroom. I found the timestamp. I played the segment. Gretchen's voice, *, did you go inside the building? Elias's voice, no. Silence. Then Gretchen, what happened next? No question about anyone else near the building. No answer about a man watching from across the street. The audio confirmed what I remembered, those words were never spoken. But my steno notes contained them. My cat translation contained them. My draft transcript contained them. They were there, in my output, attributed to the correct speakers, formatted correctly, sitting between exchanges that had actually occurred, as seamlessly as if they had always been part of the proceeding. I deleted the passage. I told myself it was a glitch, the strangest one I'd ever encountered, but a glitch. I made a note to run a diagnostic on my dictionary file. I continued editing. On page 41, it happened again. This passage was longer. 19 lines. In it, Gretchen asks Elias to describe the man he saw across the street. Elias says the man was in his 40s, wearing a dark jacket, and holding something that might have been a container. Gretchen asks if Elias had ever seen the man before. Elias says yes, twice, both times near the same building, once in July and once in early August. Gretchen asks what the man was doing on those occasions. Elias says the man was talking to someone who came out of the building's side door, someone Elias later learned was the building's owner. The building's owner. The same landlord Gretchen's defense had tried to implicate through electrical code violations. I played the audio. None of it was there. The courtroom recording jumped cleanly from one real exchange to the next, with no gap, no artifact, no sign that anything was missing. The words existed only in my steno notes and in the CAT translation derived from them. I sat in my chair for a long time. Then I did something I should not have done. I should have reported the discrepancy to the court administrator's office immediately. I should have filed a formal errata notice. I should have flagged the steno file for forensic review. Instead, I opened a browser and searched the Hennepin County property records for the building on 26th Street. The building's owner was a man named Gerald Linden. His address was in Edina. He had owned the property since 2011 and had accumulated 6 housing code violations between 2016 and 2023, 3 of which were for electrical deficiencies. He had been sued twice by former tenants. He carried insurance on the building through a company I had never heard of, and a notice of claim had been filed 11 days after the fire. An insurance claim. 11 days after a fire that destroyed his building. This was not in the trial record. Gretchen had tried to raise the issue of the landlord's maintenance history, but the prosecution had successfully argued that it was speculative and irrelevant to the question of whether Elias set the fire. Judge Oda had sustained the objection. The insurance claim was never mentioned at trial because it hadn't been filed yet when the trial began. The phantom testimony in my transcript described a man who sounded like the building's owner, watching his own property burn from across the street. A man Elias claimed to have seen at the building before. A man connected to the side door, not the front, the side, a detail so specific and gratuitous that no software error in the world could produce it. I deleted the 19 lines. I finished editing the transcript over the next 3 days. I found no further anomalies. Every other line matched the audio, matched my memory, matched the real-time feed logs. The rest of the document was clean. I ran my certification check, verified formatting, attached the signature page, and filed the transcript with the court. The official record of State versus Elias Ruiz contained exactly what was said in Courtroom 6 and nothing more. And a 15-year-old was going to be sentenced as an adult for a fire he may not have set, while the information that could have changed the outcome existed only in a steno file I had already corrected and a memory I could not certify. I want to be clear about what I did not do. I did not contact Gretchen Hauer. I did not notify the court administrator. I did not tell Mariana or Kevin or Judge Oda. I did not file a supplemental report or a motion for anything. I drove home, made dinner for my daughter, helped her with her algebra, and lay awake until 2 in the morning staring at the ceiling of my apartment on Lyndale Avenue, running the passage through my head word by word. The next morning I drove to work, set up in Courtroom 6, and wrote the proceedings for a personal injury case that lasted until 4:15. I went home. I made dinner. I lay awake. This continued for 6 days. On the 7th day I did something else I should not have done. During my lunch break, I drove to the building on 26th Street. What was left of it? The structure had been demolished in September. The fire damage was too extensive for rehabilitation, and the lot was empty except for a chain-link fence and a dumpster. I parked across the street and looked at the sidewalk where the phantom testimony said a man had been standing. It was just a sidewalk. Cracked concrete, a bus stop sign, a storm drain. Nothing. But the side door. Elias's phantom testimony had mentioned a side door. I got out of my car and walked along the fence. On the east side of the lot, partially hidden by the neighboring building's wall, I could see the remnants of a concrete stoop and a steel door frame, bent and blackened, but still standing. The side door had been real. The building had a side entrance that was not visible from the front, not mentioned in the trial testimony, and not documented in any photograph in the prosecution's exhibit list. I had reviewed the entire case file during transcript preparation. There was no side door in the record. Elias's phantom testimony knew about a door that the real trial did not. I drove back to the courthouse. I sat in the parking structure for 20 minutes. Then I went upstairs and worked until 5. That evening I pulled the steno file again. Not the corrected version, the original, unedited output from my Luminex 2's internal memory. I found the phantom passages. They were still there. The raw shorthand strokes that produced them were still there. I ran them through my dictionary manually, chord by chord. Every stroke was mine. I mean that technically, each chord corresponded to an entry in my personal steno dictionary, a dictionary I have built and refined over 11 years of practice, a dictionary that is as unique to me as a fingerprint. No one else types the way I type. My briefs, my shorthand abbreviations for common words and phrases, are mine alone. Whoever or whatever had produced those strokes was using my language. I checked the timestamps on the steno file. The phantom passages had been written in sequence with the real testimony, at the same speed, with the same rhythm. There were no pauses, no breaks, no speed changes. They had been produced during the proceeding, in real time, at approximately 240 words per minute, while I sat 8 feet from the witness stand. My fingers had moved. I must have typed them. There was no other explanation that the machine could offer me. But I had not heard those words. No one had said them. The audio confirmed it. The real-time feed confirmed it. The memory of every person in that courtroom, judge, attorneys, jury, gallery, would confirm it if asked. I had typed testimony that was never spoken, and the testimony was true. The second case was 2 weeks later. Judge Oda's docket had moved to a civil matter, a contract dispute between a commercial landlord and a restaurant group. Low stakes, tedious, the kind of case where I find my rhythm and my mind settles into the mechanical precision the work demands. 4 days of testimony about lease terms, renovation costs, and ventilation requirements. On the second day, during the cross-examination of the restaurant group's managing partner, I was writing steadily when the attorney for the landlord asked about a payment that was 60 days overdue. The witness gave a vague, evasive answer about cash flow timing. I took it down. The attorney pressed. The witness elaborated slightly. I took that down too. That evening, editing the day's output, I found 3 additional lines after the witness's evasive answer. In these lines, the witness, still attributed correctly, still formatted as testimony under oath, stated that the overdue payment had been redirected to cover a personal tax obligation unrelated to the restaurant, and that the managing partner of the landlord's company had been aware of this and had agreed to it verbally in a phone call on July 19. The audio recording contained no such statement. My memory contained no such statement. But the steno notes contained the strokes, in my dictionary, at my speed, in sequence. I stared at the passage. Then I did something I had never done in my career. Instead of deleting it immediately, I searched for it. I pulled the case file and looked for any reference to a phone call on July 19. I found nothing. But I pulled the landlord's billing records, which were in evidence as Exhibit 14, and I found a notation on the July statement, per TC with Mr. 7/19, payment deferred per agreement. *TC. Telephone call. Mr. The initials of the managing partner, *. The phantom testimony had described a real conversation that was documented in the opposing party's own billing records but that no attorney on either side had noticed or raised during trial. I deleted the lines. The correct transcript was filed. The case was settled 4 months later for an amount I never learned. It did not stop. Over the next 3 months, I found phantom passages in my steno output on 6 additional occasions. Always during editing. Always absent from the courtroom audio. Always formatted correctly, attributed to the right speakers, produced in my shorthand at my speed during real proceedings. And always, without exception, containing information that was both absent from the trial record and independently verifiable as true. In a felony assault case, phantom testimony from the defendant described a security camera at a gas station 3 blocks from the scene that neither the prosecution nor defense had subpoenaed. I found the gas station. The camera existed. It pointed directly at the intersection where the assault allegedly occurred. In a custody dispute, phantom testimony from the mother described a specific incident at the child's school, a date, a teacher's name, a conversation, that had never been raised in any filing. I checked the school's public event calendar. The date was a parent-teacher conference day. The teacher's name matched the child's actual teacher, information that was nowhere in the court file. In a fraud trial, phantom testimony from a witness described the location of a second set of financial records in a storage unit in Bloomington. I did not verify this one. I was afraid to. Each time, I deleted the passages. Each time, the certified transcript I filed contained only what was actually spoken. Each time, the information I removed was the kind of evidence that could have changed the proceedings' outcome, not dramatically, not in every case, but with the quiet structural force of a fact arriving at the right moment. I was filing accurate transcripts and destroying better ones. This is the part one cannot make anyone understand. The ethical obligation of a court reporter is absolute. The transcript reflects what was said, nothing more, nothing less. I do not interpret. I do not editorialize. I do not add. I do not omit. The certification page I sign is a legal attestation that every word in the document was spoken in my presence during the proceeding. To include testimony that was never spoken, regardless of its truth, would be falsification. It would be perjury. It would be a crime. But to exclude it was to watch the system fail, case after case, in the precise place where a single piece of true information could have made it work. I was the only person who knew, and I was the only person who could not act on what I knew, because the mechanism that delivered it to me was the same mechanism that made it inadmissible. If I told Judge Oda that my steno machine was producing true but unspoken testimony, I would lose my certification, my career, and very likely my freedom. If I leaked the information anonymously to the relevant attorneys, I would be tampering with active cases. If I did nothing, I was following the law and watching it produce injustice with my hands on the keys. I chose nothing. Again and again. In January, Mariana noticed something. We were both editing in the shared office on a Thursday afternoon. She was working on a transcript from Judge Alvarez's courtroom, courtroom 4, 6th floor, and I was finishing a DUI case from the previous week. The building was quiet. Kevin had transferred to the 3rd District in October, and his desk sat empty with a dead spider plant on the divider. "Dana," Mariana said. I turned my chair. She was staring at her screen with an expression I recognized because I had felt it on my own face many times in the preceding months. It was the expression of a person encountering something in their own output that they did not produce. "Can you look at something?" I walked to her desk. She pointed to a passage on her screen. It was testimony from a child welfare hearing, a social worker describing a home visit. In the middle of the social worker's account of the family's living conditions, there were 4 lines in which the social worker described finding a specific medication in the bathroom cabinet that contradicted the mother's sworn statement about the child's medical history. "I didn't hear this," Mariana said. "I've played the audio 3 times. It's not there." I looked at the passage. The formatting was correct. The speaker attribution was correct. The steno was clean. "It's in your notes?" I asked. "It's in my notes. My strokes. My dictionary." She looked at me. "How is that possible?" I should have told her everything. 3 months of phantom passages, 6 cases, verifiable truths produced by my own machine from testimony that never existed. I should have told her because she was my colleague and she deserved to know, and because the phenomenon, whatever it was, had just demonstrated that it was not confined to me, not confined to courtroom 6, not confined to my machine. Instead I said, "It's probably a dictionary conflict. Run a diagnostic." Mariana deleted the passage. She filed a clean transcript. She did not mention it again for 2 weeks. When she did mention it again, it was because it had happened a second time. And then a third. She came to me each time with the same bewildered expression, and each time I told her to delete and move on, and each time she did, because Mariana trusted me and I was senior and my advice was procedurally correct, and the guilty weight of that trust settled into my chest like a second skeleton. By February, Mariana and I had an unspoken understanding. We did not discuss the phantom passages in detail. We did not speculate about causes. We deleted them. We filed clean transcripts. We went home. But something had shifted between us, a shared vigilance, a new habit of glancing at each other during proceedings as if checking that we were both hearing the same thing. We were. The courtroom audio always matched what we heard. The anomalies only surfaced later, in the edit, in our own notes, in strokes our fingers had apparently made while the real testimony moved through us at 240 words per minute. And the passages were always true. Mariana verified hers the same way I had verified mine, carefully, quietly, on her own time, through public records and case files and one cautious phone call she told me about afterward, to a school administrator who confirmed a detail that should not have been in any transcript from any courtroom. "It's like the machine knows what should have been asked," she said one evening, standing in the hallway outside our office. The building was mostly empty. The overhead lights were on their half-power evening setting. "The machine doesn't know anything," I said. "Then we do," she said. "And we don't know that we know it." I had been avoiding that conclusion for months. In March, I pulled every steno file I had archived since October and ran a comprehensive comparison against the corresponding certified transcripts. Every phantom passage I had deleted was still in the original steno files on my Luminex 2's memory. I cataloged them. 14 passages across 8 cases, ranging from 3 lines to the original 19 in the Ruiz transcript. I printed them on my home printer. I locked them in the fireproof box in my bedroom closet where I keep my daughter's birth certificate and my divorce papers. Then I did something I had never done in 11 years of practice. I went back to the Ruiz case. Elias Ruiz had been sentenced in November. He received a blended sentence, juvenile disposition with the possibility of adult incarceration if he violated the terms. He was in a residential facility in Red Wing. He was 16 now. His case was closed, his conviction was on the record, and the certified transcript I had filed was the permanent, legally binding account of his trial. The transcript was accurate. Every word in it had been spoken. And 19 lines that would have pointed the defense toward a man named Gerald Linden, a side door, an insurance claim, and a pattern of visits that linked the building's owner to the scene. Those 19 lines existed only in my steno file and in the printout locked in my closet. I searched for Gerald Linden again. His insurance claim had been paid out in December. $460,000. The vacant lot on 26th Street had been sold in January to a development company. Linden had purchased a second property in Richfield in February. A man may have burned his own building for insurance money. A 15-year-old was convicted for it. And the only evidence connecting them had appeared in my transcript from nowhere, true and complete and inadmissible, and I had deleted it because it was my professional obligation to delete it. I drove to the lot on 26th Street again. The fence was gone. The dumpster was gone. The foundation had been excavated. Where the side door had been, there was now a rectangle of open earth. I sat in my car across the street and I thought, I'm the most accurate court reporter in this district, and the thing I am most accurate at is removing the truth. In April, 2 things happened that changed everything. The first was that Kevin Brandt's replacement arrived. Her name was Audrey Yoon, and she was 26, newly certified, and assigned to courtroom 9 on the 4th floor. She was fast, precise, and slightly nervous in the way that new reporters are nervous, hyper-aware of her error rate, meticulous about her dictionary file, eager to do well. I liked her immediately. I remembered being her. She had been in the building for 3 weeks when she knocked on the frame of my office door on a Tuesday morning. "Can I ask you something weird?" she said. My stomach dropped. My transcript from Friday, Judge Pham's docket, there's a section in my notes that I can't account for. It's formatted like testimony, but it's not on the audio backup. I've checked 3 times. What does it say? I asked, and I heard my own voice from a great distance. Audra described the passage. It was from a sentencing hearing for a repeat DUI offender. In the phantom testimony, the defendant's employer, who had not been called as a witness and was not present in the courtroom, described the defendant's blood alcohol level at work on 3 specific dates, information that would have materially affected the court's assessment of the defendant's pattern of behavior and possibly the sentence. "Is it in your steno?" I asked. "My strokes. My dictionary. My speed." "Delete it," I said. "But it sounds." "Delete it. File the clean transcript. Don't tell anyone." Audra looked at me with the expression of someone who has just been told to do something procedurally correct by a person who is clearly terrified and does not know which signal to trust. "Okay," she said. She left. 3 court reporters. 3 courtrooms. 3 separate steno machines with 3 separate dictionaries producing phantom testimony that was never spoken, always true, and always excised from the record by the very people whose professional integrity demanded they remove it. The second thing that happened in April was that Gretchen Hauer filed a motion for post-conviction relief in the Ruiz case. I found out because the motion crossed my desk, standard procedure, since I was the court reporter of record. Gretchen's filing argued that newly discovered evidence supported a claim that the fire's origin was consistent with an electrical failure in the building's east wall, and that the landlord's pattern of code violations constituted a viable alternative theory that had been improperly excluded at trial. She had attached an affidavit from an independent fire investigator and a copy of Gerald Linden's insurance claim payout. She had found the insurance claim on her own. Through public records, the same way I had. But she had not found the side door. She had not found the pattern of visits. She had not found the men watching from across the street. Those details existed only in my steno file, in a passage that was never spoken and that I had deleted from the transcript and printed and locked in a box in my bedroom closet. If Gretchen knew about the men across the street, her motion would be stronger. Possibly strong enough to warrant a new trial. Possibly strong enough to get Elias Ruiz out of the facility in Red Wing and back into the life that the system had incorrectly taken from him. And I could not tell her. I could not tell her because the information came from a phantom passage in my own certified transcript, a passage I had removed and then attested, under oath, did not exist. If I revealed it now, I would be admitting that I had filed a certification I knew to be incomplete. I would be admitting that I had been aware of potentially exculpatory evidence for 6 months and had suppressed it. I would lose my certification. I would face criminal charges. The transcript itself would be called into question, which would contaminate not just the Ruiz case but every case I had reported since October, hundreds of proceedings, thousands of pages, an entire district's worth of legal records suddenly unreliable because the reporter who certified them had been producing testimony from nowhere and telling no one. And if I tried to explain the mechanism, if I said, my steno machine is generating true testimony that was never spoken, I would be evaluated, not believed. The explanation would destroy the evidence. I was the instrument and the obstruction simultaneously. Gretchen's motion sat on my desk for 2 days. I read it 4 times. On the second evening, I drove to the lot on 26th Street again. The excavation was deeper now. Workers had poured concrete forms for a new foundation. The side door was gone. The stoop was gone. The last physical evidence of the entrance that only my phantom transcript described had been removed from the world. I started watching my own hands during proceedings. This is difficult to describe without sounding unhinged, but I need you to understand what it is like to sit in a courtroom, fingers on the keys, taking down live testimony, and to not know whether the strokes you are making correspond to words being spoken or to words that should be spoken. The two feel identical. The motion is the same. The speed is the same. The rhythm is the same. I have typed 240 words per minute for 11 years, and the act is so deeply embedded in my neuromuscular system that I do not consciously register individual strokes any more than you consciously register individual steps when you walk. I could not catch myself doing it. I tried. I watched my hands. I watched the real-time feed. During proceedings, the feed always matched the spoken testimony. The phantom passages never appeared in the live translation. They appeared only later, in the steno file, during the edit, as if they had been there all along but had waited to become visible until I was alone with the text. Mariana reported the same thing. Audra, when I asked her carefully, confirmed it. The phenomenon was invisible during the proceeding and visible only afterward, only in the steno, only to the reporter who had produced it. In May, I stopped sleeping well. Not because of nightmares, I was not frightened, exactly, or not only frightened. I was caught. The thing that was happening to my transcripts was producing justice, and I was the person whose job it was to prevent it. Every deletion I made was procedurally correct and morally catastrophic. Every clean transcript I filed was a lie dressed in the specific clothing of accuracy. I was following every rule and the rules were wrong, and I could not change them from where I sat, which was 8 feet from the witness stand with my fingers on 22 keys. In the second week of May, Judge Oda held a hearing on Gretchen's motion for post-conviction relief in the Ruiz case. I was the reporter. Gretchen presented her evidence, the insurance claim, the fire investigator's affidavit, the code violations. The prosecution argued that none of this was new evidence within the meaning of the statute, since the code violations had been available at trial and the insurance claim was circumstantial. Judge Oda asked careful questions. I wrote every word. When I edited the transcript that evening, I found the longest phantom passage yet. 43 lines. In it, Elias, attributed as a witness, formatted as sworn testimony, complete with question and answer structure, described in detail the 3 occasions on which he had seen Gerald Linden at the building. He described Linden's car, a dark blue Lexus SUV, and the license plate, which he had memorized because a friend had told him the car belonged to the building's owner and Elias had been curious. He described the men Linden spoke to at the side door, a man Elias did not know, who wore work clothes and carried a toolbox. He described the smell of gasoline near the side entrance on the second visit, in early August, 6 days before the fire. 43 lines. A complete, coherent, devastating account that would connect Gerald Linden to the scene, to an accelerant, and to a co-conspirator. And it was never spoken. The audio was clean. The courtroom had heard nothing of the kind. Judge Oda had heard nothing. Gretchen had heard nothing. Elias, sitting in the courtroom in his facility-issued clothes, had said nothing about any of it. But my steno file contained it. In my strokes. In my dictionary. At my speed. I sat at my desk and I looked at the 43 lines and I understood, finally, what Mariana had said in the hallway in February. It's like the machine knows what should have been asked. No. Not the machine. Me. Us. The reporters. The people who sit closer to the witness than anyone else in the room, who hear every inflection, every hesitation, every evasion, who spend their entire careers developing an ear so finely tuned to the spoken word that they can detect the shape of what isn't being said by the texture of what is. We knew. We had always known. Not consciously, not in any way we could access or articulate, but in the deep procedural layer where the work lives, in the space between hearing and typing where 11 years of testimony becomes a kind of fluency in human concealment. We could hear the gaps. We could feel the missing questions. And somewhere beneath our conscious awareness, our hands were answering them. The phantom passages were not produced by the machine. They were produced by us, by the part of us that knows what the truth sounds like and cannot stop transcribing it, even when it was never spoken. I was certain of this for approximately 48 hours. Then Audra showed me her file from the previous Friday. A phantom passage. 12 lines. From a case she had reported in Courtroom 9, a commercial lease dispute she had no personal investment in, involving parties she had never encountered, in an area of law she had no background in. The passage contained a specific account number at a specific bank. A routing number. A wire transfer date. I watched Audra's face as she explained that she had verified the account number through a public bankruptcy filing connected to one of the parties. The account was real. The routing number was real. The wire transfer date corresponded to a transaction described in a sealed exhibit she did not have access to and had never seen. Audra had been a certified reporter for 7 months. She had no deep procedural intuition about commercial finance. She had no unconscious fluency in wire fraud. She had reported the case for 2 days and felt nothing unusual. And her steno file contained a routing number she had no conceivable way of knowing. My theory collapsed in the time it took her to read me 9 digits. It was not us. It was not unconscious expertise. It was not some latent pattern recognition capacity in the court reporter's trained ear. Whatever was producing the phantom testimony had access to information that existed nowhere in the courtroom, nowhere in the reporter's experience, nowhere in any record we could reach. And it was using our hands. I am in my car in the parking structure. It is now 6:51. My daughter texted me 20 minutes ago asking when I will be home. I told her I was running late. The 43 lines from the Ruiz hearing are in my bag. I printed them this afternoon, on the 9th floor printer, while the building emptied around me. They are on Hennepin County letterhead because that is the paper that was in the tray. They look official. They look like a transcript page. Gretchen Hauer's motion for post-conviction relief is still pending. Judge Oda has not yet ruled. If the motion is denied, Elias Ruiz will remain in the facility in Red Wing until he ages out of the juvenile disposition, at which point the adult sentence will activate, and he will go to prison for a fire he did not set, based on a trial record that is accurate and incomplete, accurate because I certified it, incomplete because I did what I was trained to do. In my bag, beneath the 43 lines, is the certification page from the original Ruiz trial transcript. My signature is on it. My oath is on it. It says, I certify that this is a true, correct, and complete transcription of the proceedings. Complete. I signed that word. I knew it was wrong when I signed it. I don't know what is producing the phantom testimony. I don't know how it accesses information none of us possess. I don't know why it uses our hands, our dictionaries, our specific shorthand, as if it can only speak through the instrument that is already dedicated to recording the truth. I don't know if it is something in the machines, something in the courtrooms, something in the process of transcription itself, some resonance between the act of capturing speech and the speech that should have existed but didn't. I don't know any of that. What I know is this. I have 43 lines of testimony that Elias Ruiz never spoke, containing information I cannot explain, describing events that are almost certainly real, in a format that is indistinguishable from a certified transcript page. If I give them to Gretchen Hauer, she will ask where they came from. I will not be able to answer. She will investigate. The investigation will lead to my steno files. My steno files will show passages I deleted from certified transcripts across 8 cases over 7 months. My career will end. My certification will be revoked. Every transcript I have ever filed will be subject to challenge. Judge Oda's courtroom will be shut down for review. Mariana and Audra will be pulled into it. The cascade will move through the building and into the district and from there into every case that depends on the integrity of a court reporter's oath. And Elias Ruiz might go free. If I don't give them to her, nothing changes. The record stands. The record is accurate. The record is what I swore it was. And a 16-year-old stays in Red Wing for the procedural crime of not being asked the right questions by an underfunded attorney in a system that worked exactly as designed. I have been sitting in this car for 47 minutes. The parking structure is almost empty. The concrete walls amplify every sound, a door closing somewhere below me, a car starting on the level above, the tick of my engine cooling. My bag is on the passenger seat. The 43 lines are in it. I haven't decided. But my hands are shaking, and they haven't shaken during a transcript in 11 years, and I'm watching them now the way I've been watching them for months, trying to determine whether the next thing they do will be my choice or something else's. Gretchen's office is 14 minutes from here. My apartment is 12. The engine is off. The key is in my hand. I have to turn it one direction or the other, and the record, the permanent, certified, unalterable record, will reflect exactly what I do next, and nothing that I should have done instead. The parking structure's fluorescent lights cycle on a timer. At 7 o'clock they shift from full to half power, and the ones on level 3, my level, have a 2-second delay before they catch up. I've parked here almost every working day for 7 years, and I know the exact moment the light changes the way I know the rhythm of a judge clearing her throat before sustaining an objection. These are the textures of a professional life. They accumulate without your permission and they become the architecture you live inside. At 7:02 the lights dimmed. I opened my bag. The 43 lines were on top, folded once. Beneath them was my laptop, my Steno Notes backup drive, my lunch container, and the small leather case where I keep spare steno paper and a backup battery for the Luminex 2. A court reporter's bag is not dramatic. It contains the tools of transcription and the residue of a working day. But the folded pages on top were not tools. They were evidence of something I couldn't categorize, not a transcript, because the words were never spoken, not a fabrication, because the information was true, not my work, because I didn't consciously produce it, not someone else's, because every stroke was in my dictionary. I unfolded them and read the passage again under the parking structure's half-light. Lines 1 through 7, Gretchen's phantom question establishing that Elias had been in the neighborhood regularly during July and August. Elias's phantom answer describing the dark blue Lexus SUV, the license plate, 487 MKD, and the 2 prior occasions he had seen it parked within a block of the building. Lines 8 through 19, Gretchen's follow-up about the men at the side door. Elias's description, work clothes, heavy build, toolbox, entering through the side entrance while Lyndon waited in the car. The specificity of the detail was what had undone me the first time I read it. Not the broad strokes, which could theoretically be confabulated from publicly available information about the building's ownership and maintenance history, but the granular, sensory details. The toolbox was red. The men whistled while he walked. The side door stuck at the bottom and had to be kicked open. These were the kinds of details that a person who had been there would remember and that a person who had not been there could not invent. Lines 20 through 31, the July visit. The August visit. The smell of gasoline near the side entrance. Elias's phantom testimony that he had not reported this to anyone because he did not know it was significant until after the fire, and because by then he was in custody and his attorney had never asked him about it. His attorney had never asked him about it. That line more than any other was the one that kept me in the car. Because it was not an accusation. It was not dramatic. It was the quiet, factual observation of a 15-year-old who had information that could have changed everything and was never given the opportunity to provide it. Gretchen hadn't asked because she didn't know to ask. The prosecution hadn't explored it because their theory didn't require it. Judge Oda hadn't prompted it because judges don't prompt, they preside. The system had functioned correctly at every node, and the result was a conviction built on the absence of a question. Lines 32 through 43, the license plate verified against a DMV record I had no legal access to. The insurance claim timeline. The name of the co-conspirator, Darren Voigt, a licensed electrician whose business address was in Brooklyn Park and whose contractor's license had been suspended in 2021 for a code violation in Anoka County. I had not verified any of this. I had not searched for Darren Voigt. I had not run the license plate. The 43 lines contained claims that I could not confirm from public records and that might or might not be true, and the only way to find out was to give them to someone with subpoena power. Someone like Gretchenhauer. My phone showed 7:09 p.m. My daughter had texted again, "Mom, are you okay?" I typed, "Fine." 15 minutes. I did not start the car. There is something I have not described yet that I need to describe now, because it bears on what I eventually did, and because leaving it out would make this account incomplete in a way that I have spent 7 months learning to recognize as a specific kind of professional failure. In the third week of April, after Audra's routing number had collapsed my theory about unconscious reporter expertise, I went back to my archived steno files and did something more systematic than my earlier review. I created a spreadsheet. Every phantom passage, every case, every date, every courtroom, every reporter. I included the subject matter of each passage, the type of information it contained, and whether that information had been verified. 14 passages from my files. 7 from Mariana's. 4 from Audra's. 25 total. I sorted them by date. Then by courtroom. Then by case type. Then by the nature of the phantom information. No pattern emerged from the dates. No pattern from the courtrooms, 3 different rooms, 3 different floors, 3 different judges. No pattern from the case types, criminal, civil, family, commercial. The phenomenon did not favor any docket, any judge, any area of law. But a pattern emerged from the information itself. In every single case, the phantom testimony supplied the answer to a question that should have been asked and wasn't. Not a question that would have been nice to ask, or interesting, or tangentially relevant. The specific question whose absence allowed an incomplete picture to become the official picture. The question that, had it been posed by a competent attorney with adequate time and resources, would have produced a piece of evidence that materially affected the proceeding's outcome. In the Ruiz case, the question was, did you see anyone else near the building? In the contract dispute, the question was the deferred payment documented in any written communication? In the assault case, the question was, are there any surveillance cameras in the immediate vicinity of the intersection? Every phantom passage was an answer to an unasked question. And every unasked question had been left unasked not because of malice or corruption or incompetence, but because of the ordinary structural constraints of the system, underfunded defense attorneys, overloaded dockets, time-limited cross-examinations, pretrial rulings that narrowed the scope of inquiry, judges who managed their courtrooms efficiently because efficiency was the only way the volume could be sustained. The phantom testimony was not correcting errors. It was filling gaps. Gaps that the system produced as a normal function of its operation. Gaps that no one was responsible for because everyone was following the rules, and the rules, followed correctly, generated an incomplete record as their standard output. I stared at the spreadsheet for a long time. Then I added one more column, outcome if included. Case by case, I assessed what would have changed if the phantom passage had remained in the certified transcript. In 9 of the 25 cases, the passage would have introduced evidence favorable to the party with fewer resources, the public defender's client, the pro-se litigant, the respondent without counsel. In 6 cases, it would have surfaced information that neither party had access to but that was relevant to the court's determination. In 4 cases, it would have contradicted testimony that was accepted as credible. In the remaining 6, the effect was ambiguous, information that was true and relevant but whose impact on the outcome I could not confidently predict. In no case, not one, did the phantom testimony favor the better resourced party. I closed the spreadsheet. I closed my laptop. I sat at my desk in the empty office and listened to the building's HVAC system push dry air through the vents, and I thought about the oath I had taken when I was certified. Do you solemnly swear that you will faithfully and accurately report the proceedings? Faithfully. Accurately. Report. I had always understood those words as referring to the proceedings as they occurred. The spoken words. The record as made. But the phantom passages were also faithful to a truth that the proceeding had failed to reach. They were accurate, every verifiable detail confirmed. They were a report, formatted, attributed, complete. They were just not a report of what happened. They were a report of what should have happened. And I did not know who or what was writing them, and I did not know why, and the distinction between those two categories of report, what happened and what should have happened, was the entire foundation of my profession. On May 6th, I made a decision that I told myself was procedural and that I knew was not. I stopped deleting the phantom passages from my working files. I continued to exclude them from the certified transcripts. The official record remained clean. My certifications remained truthful in the narrow, technical sense that every word in the filed document had been spoken in the courtroom. I was not committing fraud. I was not falsifying records. I was simply retaining my steno notes in their unedited form, which was not required but was also not prohibited. Court reporters are encouraged to maintain their raw steno as a backup, and many of us archive our machine files indefinitely as a matter of professional practice. I was keeping the truth in a format that no one would ever read, and I was filing the record in a format that no one would ever question. This felt like a compromise. It was not a compromise. It was a filing system for cowardice. I told Mariana what I was doing. She stared at me for a long time and then she said, "I've been doing the same thing since March." Neither of us told Audra, though I suspect she arrived at the same practice independently, because she stopped asking me about the passages and started asking me about steno file archival policies, and the questions had the careful, peripheral quality of someone who is building a structure around a decision she has already made. 3 court reporters in the Hennepin County Government Center, maintaining parallel archives of testimony that was never spoken, verified as true, and excluded from the legal record by the people whose job it was to create it. On May 12th, a Monday, I was setting up in courtroom 6 for the morning docket when the courtroom clerk, Linda Okafor, handed me a scheduling note. Judge Oda was hearing 2 matters that day, a pretrial motion in a commercial fraud case at 9, and a continuation of the Ruiz post-conviction relief hearing at 1:30. Hauer filed supplemental exhibits over the weekend, Linda said. Fire investigation stuff. Oda's going to let her present them. What kind of exhibits? Electrical panel photographs. Some kind of contractor report. I nodded. I set up my machine. I tested my keys. I loaded my dictionary. I checked the backup audio. The courtroom was cold. The HVAC system in the 8th floor courtrooms runs aggressively in May, and courtroom 6 has always been the coldest. I adjusted the angle of my laptop screen and waited. The morning session was unremarkable. Commercial fraud. 3 witnesses. 7 sustained objections. My hands moved at the usual speed and the real-time feed displayed the usual clean translation and I felt the usual deep concentration that is neither thought nor its absence but something between, a state of pure linguistic receptivity that I have never been able to describe adequately to anyone who doesn't do this work. No phantom passages appeared in the real-time feed. They never do. The feed is always clean. The ghosts wait. During the lunch recess I went to my office and ate a turkey sandwich at my desk. Mariana was there. We did not speak about anything related to transcripts. We talked about her son's baseball game and about the construction project on Washington Avenue that was making the walk from the parking structure unpleasant. At 12:50 I threw away my sandwich wrapper and went back to courtroom 6. Gretchen Hauer was already at the defense table. She was younger than me by several years, late 30s, dark hair pulled back, the kind of focused, slightly harried energy that public defenders develop as a survival mechanism. She was reviewing a folder of documents. Behind her, in the gallery, sat a woman I did not recognize, mid-50s, Vietnamese, small, with bandaged hands that she held very still in her lap. Tan Pham, the burn victim. She had come to the hearing. Elias was brought in by a facility escort at 1:25. He was taller than I remembered from the trial. His hair was shorter. He sat at the defense table next to Gretchen and did not look at the gallery. Judge Oda took the bench at 1:30 exactly. She always does. The bailiff called the case. I positioned my hands on the keys. What followed was a hearing. I will describe it as precisely as I can. Gretchen presented her supplemental exhibits, photographs of the building's electrical panel, taken by the fire department during the initial investigation but not included in the prosecution's exhibit list at trial. She had obtained them through a FOIA request. The photographs showed a panel that had been modified, conduit rerouted, breakers replaced with mismatched components, in a way that was inconsistent with any permitted electrical work on the property. She presented an affidavit from a licensed electrician who stated that the modifications created a significant fire risk and were consistent with the type of failure that could produce the burn pattern documented in the fire investigator's report. The prosecution objected. The photographs had been available in the fire department's file at the time of trial, making them not newly discovered evidence under the statute. Gretchen argued that the defense had requested the full investigative file pre-trial and the photographs had not been included in the prosecution's disclosure. There was a dispute about the scope of the original discovery order. Judge Oda reviewed the pre-trial filings on her screen. The discussion lasted 34 minutes. I wrote every word. At 2:27, Judge Oda asked Gretchen if she had any further evidence to present. Gretchen said no. The judge asked the prosecution if they wished to respond. They did. The prosecutor argued that even if the photographs were newly discovered, they did not establish that the fire was electrical in origin, only that the building had electrical deficiencies, which was already known. The electrical modifications could have been present for years without causing a fire. The jury had heard testimony about the building's condition and had still convicted. At 2:43, Judge Oda said she would take the matter under advisement and issue a written ruling. She asked if either party had anything further. Gretchen said, "No, Your Honor." The prosecutor said, "No, Your Honor." Judge Oda looked at the gallery. Her gaze passed over Tan Pham's bandaged hands. Then she looked at Elias, who was staring at the defense table. Then, and I registered this only because I register everything in the courtroom, it is what my hands are for, she looked at me. Not at my machine. Not at my screen. At me. At my face. For approximately 1.5 seconds. "We're adjourned," she said. The bailiff called the courtroom to its feet. Judge Oda left through the chamber door. The prosecutor packed his files. Gretchen spoke quietly to Elias for several minutes. The facility escort waited by the side door. Tan Pham sat in the gallery with her hands in her lap and did not move until Elias was let out, and then she stood and left without speaking to anyone. I packed my equipment. I returned to my office. I opened the steno file from the afternoon hearing. I scrolled through it slowly. Page by page. Line by line. The entire hearing, every objection, every argument, every word from Judge Oda, was present and accurate. And at the end of the file, after the judge's final "we're adjourned," there were 11 additional lines. They were not formatted as testimony. They were not attributed to any speaker. They had no question and answer structure. They were in my steno, in my dictionary, at my speed, but they did not look like anything I had ever produced. They looked like a note. The 11 lines contained the following information: Darren Voigt's current address in Brooklyn Park. His phone number. The name and case number of the 2021 Anoka County Contractor's license suspension. The name of the insurance adjuster who had processed Gerald Linden's claim. And a single sentence at the end that I read 3 times before I understood what it meant. The backup audio from October 14 contains a 43-second segment at timecode 2 hours 14 minutes and 7 seconds that was not present during the initial transcript review. I put my hands flat on my desk. I held them there. I counted my breathing. Then I opened the October 14 backup audio file, the file from Elias's trial testimony, and navigated to timecode 2 hours 14 minutes and 7 seconds. The audio played. I heard the courtroom ambience, the ventilation hum, the faint creak of someone shifting in a chair. Then I heard Gretchen's voice ask the question she had never asked. Did you see anyone else near the building? And I heard Elias's voice answer. There was a man. On the sidewalk across the street. He was watching. The exchange continued. Question and answer. Gretchen and Elias. 43 seconds of testimony that had not been on this recording when I checked it in October, that had not been on this recording when I checked it in November, that had not been on this recording in any of the 6 times I had played this file across 7 months of sleepless verification. It was there now. The audio file's metadata showed no modification. The timestamp was continuous. The waveform was seamless. There was no edit, no splice, no artifact. The 43 seconds sat inside the recording as if they had always been there, surrounded by testimony I had verified dozens of times, in a file that was stored on a county server with access logging that would show no unauthorized changes. The testimony was in the audio now. It was in my steno notes. If I produced a supplemental transcript from the original October proceeding, both sources would agree. Both would show the same words. Both would be verifiable, authentic, untampered. The phantom had become the record. I sat at my desk for a very long time. Mariana left at 5. The building quieted around me. The lights in the hallway switched to half power. I heard the distant clang of the elevator doors and the muffled sound of the custodial crew beginning their evening rounds on the floor below. I pulled up the other cases. The contract dispute. The assault case. The custody hearing. One by one, I opened the backup audio files and navigated to the timestamps where the phantom passages had occurred. In every file, the audio now contained the testimony. Every passage I had deleted from my transcripts, every phantom question and answer that I had verified as absent and then removed, was now present in the backup recordings, seamlessly integrated, indistinguishable from the testimony that had always been there. The evidence I had spent 7 months excluding from the record had migrated into the record on its own. I am in my car. It is now 7:34 p.m. I understand what has changed and I understand what has not. What has changed? The 43 lines of testimony in the Ruiz case are no longer unsupported. They exist in the backup audio. They exist in my steno. If I produce a supplemental transcript and certify it as a correction to the original filing, the certification will be, technically, verifiably, in every way that a court can assess, true. The testimony will match the audio. The audio will match the steno. The correction will look like what it has always been procedurally permitted to be, a reporter discovering an omission during a subsequent review of her notes and amending the record. I will not need to explain phantom passages. I will not need to describe machines producing testimony that was never spoken. I will not need to destroy my career or Mariana's or Audra's. I will file an amended transcript, notify the court and both parties, and the supplemental pages will enter the Ruiz record through the normal channels. Gretchen will see the testimony about the men across the street. She will investigate. She will find Gerald Linden and Darren Voigt and the insurance claim and the side door that no longer exists but that two witnesses, one real, one phantom, now indistinguishable, have described under oath. This is what has changed. What has not changed is that I know. I know those words were never spoken. I know the audio was empty 6 months ago and is full today. I know that whatever is producing the phantom testimony has now demonstrated a capability I had not imagined, not just filling gaps in the steno, but filling gaps in the audio, in the server, in the evidentiary infrastructure of the 4th Judicial District of the state of Minnesota. It does not just add to my notes. It adds to the record. It retroactively constructs the evidence trail that makes its additions certifiable. It is not asking me to lie. It is building the conditions under which telling the truth it has decided should exist, becomes procedurally indistinguishable from doing my job. And the part of this that I cannot stop thinking about, the part that has kept me in this car for over an hour while my daughter waits and my engine cools and the parking structure empties around me, is this. If I file the amended transcript, I will be doing the right thing for the wrong reason. Elias may go free. The system may correct itself. Justice may be served. And the mechanism that produced that justice will be invisible, untraceable, and permanently embedded in the record of the 4th Judicial District, where it will continue to produce testimony that was never spoken and evidence that materializes after the fact, and no one will ever know because the only people who could detect it, the reporters, are the people it has trained to stay silent. I will not be covering up a lie. I will be certifying a truth that manufactured its own provenance. And tomorrow morning, I will set up in courtroom 6 at 7:45. I will place my Luminex 2 on the small desk to the left of the bench. I will connect my laptop. I will open Eclipse. I will test my keys. I will check the backup audio. And my hands will move at 240 words per minute, and I will not know, I have never known, I realize now, whether every word they produce belongs to the person who spoke it, or to something older and more patient that has been listening to this system fail for longer than I have been alive, and has finally learned how to file the correction itself. The key is in my hand. Gretchen's office is 14 minutes from here. The supplemental transcript is already formatted on my laptop. The certification page is ready. It requires only my signature, the same signature I have applied to every transcript I have ever filed, the one that says true, correct, and complete. It has never felt heavier than it does right now. But Tan Pham's hands were bandaged in the gallery today, and Elias did not look up from the table, and the question that should have been asked in October is now, somehow, impossibly, permanently, on the audio recording that the county will accept as authentic. I am starting the car. I am going to Gretchen's office. And I am going to certify every word.